Good evening, everybody. Dr. V.R.S. Sampath, my best friend and editor of Sattakadir. Honorable Mr. Justice Kalayarasan, Chairman, Tamil Nadu Official Language Commission. Honorable Mr. Justice Indira Banerjee, who will be addressing the conference at any time. And Honorable Minister of Law, Government of Tamil Nadu, Mr. Raghupati. And Honorable Mr. Justice Durai Karunakaran, former Chief Justice of Seychelles, and my dear friend and senior advocate and Vice Chairman of the Bar Council of India, Mr. Prabhakaran, Mr. Saravanan, our Chairman, Salem Law College, Mrs. Nalini, former President of the Women Lawyers Association, Professor Anand Mishra, Director of Jindal Global Law College, Law School, and Dr. Muthiwed, member, Tamil Nadu Official Language Committee. I am here to share my thoughts on judicial legislation and separation of powers. See, the preamble of Indian Constitution proclaims India to be a sovereign, democratic, socialist, secular republic. Thus, democracy lies at the foundation of Indian politics. And democracy means the government of the people, by the people, and for the people. It is the representative of the people, the elected representative of the people in parliament, who has to govern the people by enacting appropriate laws which will be applicable to the citizens of this country. And it is the constitution which is supreme as far as our country is concerned, or not only our country, every country. But in a quasi-federal country like India, constitution is supreme. The supremacy of the constitution is unquestionable and indisputable. The constitution has created three limbs of government: the legislature, the executive, and the judiciary. The legislature has been entrusted with the job of making the law, the executive to execute the law so made, and the judiciary to interpret the law when they are called upon to do so. The constitution has given thus a clear-cut defined role for each limb of the government, and each one and each limb of the government is expected to act within the bounds of the constitutional jurisdiction delineated and demarcated under the Constitution of India. This separation of powers to each of the limbs of government and a duty not to encroach upon the other limb of the government is called the theory of separation of powers. It is called the theory of separation of powers, the principle of separation of powers, or the doctrine of separation of powers. Howsoever it is called, this doctrine of separation of powers had been read as an integral, inevitable, interwoven part of the basic structure of the Constitution. All of us are aware that in Kesavananda Bharati case, the 13 judges bench of the Supreme Court delivered a judgment by a majority of 7-6 regarding the amendability of the Constitution by the Parliament. And it was held that the Parliament can amend any part of the Constitution, including the fundamental rights, but such amendment should not affect the basic structure of the Constitution. Even the Parliament is precluded from amending the basic structure of the Constitution, and separation of powers is one of the integral part of the basic structure. Therefore, looked at in this angle, we have to see what is the sanctity and the validity of judicial legislation. What is judicial legislation? Judicial legislation is the law made by the pronouncement of the judiciary or by the judges who depart strictly from the interpretation of the law and lay down certain directions and guidelines which will govern the people of the state or the country. The theory of separation of powers, which has been read as a basic structure of the Constitution, had been breached many a times by the Supreme Court, is a real concern which has been expressed by the legal pundits over the years. Let us see, the Supreme Court has time and again had invoked Article 32, Article 142, and they say that we are invoking Article 32 and 142 to do complete justice. And I'm sorry to say that in the guise of interpreting the constitution. They are making judicial legislation. In the supposed to be rendering complete justice, in the guise of rendering complete justice, they lay down the law, which is the exclusive prerogative of the parliament given by the constitution. Say, for example, an analysis of the various judgments of the Supreme Court, right from 26 January 1950, when the constitution was given, till date, would reveal that the Supreme Court has transgressed its limits many a time, invoking these articles. What is the development of judicial legislation in our country? If you ask me, from 1950 to 1975, things were going on smoothly. In the sense, the judiciary, executive, and the legislature were observing their territorial functions, and they were not encroaching into the powers of the other. But unfortunately, after 1975, or somewhere in the beginning of the 1980s, the judges' appointment case is cited as a classical example of a judicial legislation. See, the Constitution of India, as was originally given, stated that the judges of the Supreme Court and High Court will be appointed by the President of India, mind you, by the President of India, in consultation with the Chief Justice of India, and in the case of Supreme Court judges, and in consultation with the Chief Justice of the High Court, in the case of High Court judges. That was the written constitution that was given to us by the Constituent Assembly. What happened? In the first judge's case, the Supreme Court said it is not consultation, it is concurrence. In fact, whether it is consultation or concurrence was debated in the Constituent Assembly, and Constituent Assembly preferred consultation rather than concurrence. But the Supreme Court, doing violence to the language and by way of judicial, not only judicial legislation, judicial amendment of the Constitution affecting the basic structure of separation of powers, said consultation means concurrence, and not only concurrence, primacy of the opinion of the Chief Justice of India in the guise of judicial. It is unheard of in other countries. In all other countries, even including America, it is the president who appoints the judge. But India is the only country where judges appoint themselves, not under the powers conferred on them by the Constitution, but under the powers appropriated by them to themselves. So this is the first classical case of judicial legislation, which has been quoted in all the lectures by legal pundits and legal women. Then there are other cases. If you see the evolution of the concept of public interest litigation. See, the public interest litigation was originally conceived to help the socially and economically disabled person who cannot approach a court of law because of financial penury or social disability or any other reason. But what was conceived in the interest of the have-nots had been appropriated by the judiciary as a tool of judicial legislation. Most of the public interest litigation, the Supreme Court had laid down laws which will govern the country as a whole. For the first time in 1990, if I can say so, the famous Vishaka case, where the Supreme Court said, we are laying down guidelines and we are giving directions with regard to the regulation of the sexual harassment of women in workplaces. That was wholly uncalled for. That was wholly unconstitutional. However, the Vishaka case started. Vishaka case, virtually the Supreme Court legislated on sexual harassment of women in workplaces. It was only thereafter that the Parliament made the law. But when making the law, the judiciary said these guidelines and directions would be there till the Parliament intervenes and makes the law. That means one is tempted to think. I mean, many other lecturers and many other legal pundits have expressed the same view. I am not the first one to say that. Many pundits feel that judiciary is acting as the third chamber of Parliament, the superior chamber of Parliament above the Lok Sabha and the Rajya Sabha. The Vishaka case is one aspect of the matter. And the very next year, in 1998 or 1999, Vineet Kumar case. In Vineet Kumar case, the Supreme Court went a step further and said, look here, whenever there is a gap in the legislation, the judiciary is entitled to fill the gap. We do not know the Constitution, whether the Constitution contains such a power. It obviously doesn't contain such a power. if you go by the 13 judges bench judgment of the Supreme Court, which says separation of powers is the basic structure of the Constitution, the basic structure of the Constitution cannot be breached, abridged, or altered, or amended by any member of the government. A creature of the Constitution, namely the judiciary, or the executive, or the legislature, cannot control the Constitution. Nobody can be a Frankenstein's monster. Therefore, the judiciary went on unabated in making judicial legislation in Vinit Kumar case. And in fact, in Vinit Kumar case, I quote the observations of the Supreme Court. I quote, there are ample powers conferred by Article 32, read with Article 142, to make orders which have the effect of law by virtue of Article 141, and there is mandate to all authorities to act in aid of the orders of this court as provided in Article 144 of the Constitution. In a catena of cases, these are the words of Supreme Court, the decisions of this court, this power has been recognized and exercised, if need be, by issuing necessary directions to fill the vacuum till such time the legislator steps in to cover the gap or the executive discharges its role, wherefrom they got the power, but the Supreme Court says so. After so observing, detailed directions were issued to the executive, formulating the guidelines to fill up the legislative vacuum and issue directions for public corruption, with regard to public corruption. But Supreme Court woke up a little bit later, in 2009, in a later judgment, in the case of injury, destruction of public and private property versus state of AP, taking a serious view of the various acts of vandalism that has been committed during the Garros, Hartals, Band, and other social disruption. The Supreme Court suo motu took the proceeding with regard to the destruction of cost to the public and private property because of these agitations. And in fact, the Supreme Court appointed two committees, one headed by a former judge of the Supreme Court, Justice K.T. Thomas, who hails from Kerala, and another committee, two committees were simultaneously appointed, one headed by Justice K.T. Thomas, the other headed by an eminent jurist of our country, Mr. Senior Advocate Haile Nariman. Both the committees went into the matter regarding the destruction of public and private property and then submitted a report saying that these are the guidelines and directions which have to be contained and incorporated in order to prevent the destruction to the public property. But Supreme Court then observed, these are all the directions which we cannot give positive directions. These are all the recommendations which we would commend the government to make appropriate legislation to fill the gap so that the destruction of public property or a private property during the times of agitation, Bandh or Hartal, could be saved. So Supreme Court later on woke up and said, look here, we would not give any directions, by positive directions binding on the people. It is the job of the legislator, but we only request the legislator to bring in suitable legislation based on the recommendations of the committee. Therefore, that is one judgment where the Supreme Court has it has taken a slight U-turn on the subject. And before that, in Volga Tele's case, that is famously known as the Bombay Payment Dwellers case, and then Union Carbide case, popularly known as Bhopal Gas Leak case, and the Asian Games case, the Supreme Court had interfered in executive actions and legislative actions and issued directions, notwithstanding the fact whether they are implementable, whether financial resources are available at the command of the government and all that. So from 1980 onwards, the concept of judicial legislation were going on unabated. But in 2009, the Supreme Court realized that there are limits. After all, it was the Supreme Court, a 13 judges bench of Supreme Court, which said separation of powers is the basic structure of the Constitution. In fact, the Supreme Court struck down two constitutional amendments. All of us would remember Constitution 99th Amendment stating where the National Judicial Appointments Commission Act was struck down, 99th Constitutional Amendment, saying that the presence of a law minister in the selection committee is an affront to judicial independence. Therefore, it was struck down by a majority of 4:1. Mind you, by a majority of 4:1, a constitution amendment was struck down, which constitution amendment was passed by 2/3 of members of Lok Sabha, 2/3 of members of the Rajya Sabha, and more than 50% of the states. Nearly 21 states in the Indian Union have passed the constitutional amendment. But by 4%, the legal women, it has been struck down. Until today, the concept, the question of appointment of judges to Supreme Court and High Court, the transfer of judges with impunity without any reason in a opaque manner is a matter of controversy amongst the legal pundits in the legal circle. This is one aspect of the matter. Later on in Madhuri Patel case, another aspect of judicial legislation, the Supreme Court said, you constitute a district committee, you constitute a state committee to scrutinize the certificate issued in favor of the scheduled caste and scheduled tribes, so as to find whether it is valid or not. These are all concepts of judicial, these are all examples of judicial legislation, which has been frowned upon by the legal fraternity, not only by the legal fraternity. Now I am going to read an extract from an article written by former judge of the Supreme Court, Justice Markandeya Kajju. He has co-authored an article, and this article was published in the Hindu regarding judicial legislation. And he says, I quote, the Bill of Rights in the US Constitution talks of freedom of speech and of the press, liberty and equality, but it nowhere mentions any right of privacy. He says the right to privacy is nowhere there in the Indian Constitution or the American Constitution. But US Supreme Court says there is a right to privacy. Indian Supreme Court says there is a right to privacy. Where do you find it? In fundamental rights, from Articles 12 to 35, one is not able to see a right to privacy at all. But the Supreme Court creates a fundamental right, which is not there a cup of tea. But that is what he says. The Bill of Rights of the US Constitution talks of freedom of speech and of the press, liberty and equality. But it nowhere mentions any right to privacy. So by a judicial verdict, a right cannot be created, which in our submission is wrong. Creating a right is wrong, according to Justice Kajju. And he says, we regret to say that both US as well as the Indian Supreme Court have not been observing judicial restraint expected of judges of superior courts and have been encroaching on the domain of the other two organs of the state, the legislature and the executive. And he gives some examples. According to him, he gives some examples. That's in Markandeya Kajju. He says, in state of Tamil Nadu versus K. Balu, the Supreme Court banned liquor shops within 500 meters of the highway. On a highway, there are motels we have seen. They say 500 meters away from the highway only, you can have a liquor shop, which was a legislative order. That is not the duty or responsibility of the Supreme Court. That's what he says. Again, in Puttasamy case, we know that Puttasamy versus Union of India, the Supreme Court said a right to privacy is a fundamental right. Where from we get that? From Article 12 to Article 35, I have scanned the entire Constitution. We don't get 395 articles. We don't get a right to privacy at all. You can't implant a fundamental right by an implication, by a judicial legislation. That is what he says. Further, he goes on to say, in Subhash Kashinath Mahajan case, it amended the SC/ST Act. Recently, we saw the SC/ST Act was amended by a judicial legislation. Even the parliament was annoyed. The entire country was annoyed. Therefore, they have brought in a legislation to cure the judicial verdict, to set aside the judicial verdict, because the Supreme Court has overreached. They have crossed the judicial restraint expected of them. That is what Dr. Kajju says. And the Sabarimala case, entry of women into Sabarimala temple, he says that is another instance. And LGBT cases. These are all cases where the Supreme Court has laid, the Supreme Court has crossed the limit. And he even says, bursting of crackers in Deepavali. What is the time? Where is the place? These are not for the Supreme Court to say. Unfortunately, it is the job of the executive or the judiciary, not that of the Supreme Court at all. That is what Justice Kajju says. Therefore, he says, we submit, I'm quoting from his article, we submit that this judicial activism requires reconsideration, for it entails unpredictability in the law, apart from violating the principle of separation of powers. It entitles each judge to lay down the law according to his own personal perception and subjective notions. We submit that courts which should be restrained to follow positivist jurisprudence, which advocates judicial restraint, and in which the center of gravity of the legal system is statutory law rather than the sociological jurisprudence, which advocates judicial activism and shifts the center of gravity in the legal system to judge-made law. In our view, this is a significant sentence. In our view, judicial legislation is an oxymoron, meaning thereby judicial legislation is a contradiction in terms. Judicial legislation is antithetical. What is meant for the judiciary is not meant for the legislature. Now, coming to my own view. In my view, The tendency of the courts and the judges to legislate and pass executive orders, mostly in public interest litigation, is perhaps the greatest reason why there are huge pendency of cases and backlog of cases which are increasing day by day. Instead of deciding constitutional issues and interpreting the Constitution, Supreme Court is going on deciding only political questions and political issues, spending much time on that. As a result, they are not able to put their own house in order. Say, for example, we have got 1,098 sanctioned the strength of High Court judges. So in 25 High Courts in the country, 1,098, of which more than 350 vacancies are there. Not today, and not yesterday, but more than 2 years. 30% of the vacancies in judiciary is there, even though law contemplates the practice is the appointment of a new judge can be initiated 6 months prior to his retirement. The retirement of a judge is well known because a High Court judge retires at the age on completing the age of 62 years. Supreme Court judge retires on completing the age of 65 years. The date of retirement is well known, and the practices and the law also permits you to start the procedure before 6 months before the retirement of the judge. But despite that, for 2 years and 3 years, a vacancy, a judge who has retired 2 years back, or rather 2.5 years back, his vacancy still subsists. There are about 350 vacancies out of 1098. This is what people are lamenting on our Law Day lectures. So various legal pundits. In fact, this is what they say, because if you are encroaching into the other's field, you forget to do your own duty. That is the simple logic. It is no surprise that as on date, so many vacancies are there in the judge. And now I am saying, number of cases involving constitutional questions. Say, for example, our own reservation. See whether subclassification is possible in backward class and backward class, right? Or scheduled class and scheduled tribe. One judgment, Chinaya took the view, it is not possible. Another judgment where Arundhati's case, Supreme Court took the view, it is possible. Both are 5 judges bench. So the matter has been referred to a 7 judges bench. Not now. Maybe last year itself, the matter was referred to 7 judges. The bench has not been constituted. So these are all the questions, burning questions, which the Supreme Court has to devote more attention to, rather than deciding questions regarding bursting of crackers, wearing of helmets, and whether the agitation about the farmers. Because the executive should take care of their own lives, their own field. We are not, judiciary is not supposed to go into that. And this is, that's the reason why there is a backlog of cases that are continuing. And I tell you, and the people are losing faith in the justice delivery system because of the backlog of cases. They are resorting to extra judicial remedy. Now I come to the present Attorney General's observation. The present Attorney General, an eminent jurist, mind you, he was enrolled as a lawyer in the year 1954. He is now completed 67 years of practice, and now he is aged 89 years. He is a constitutional lawyer, and his father was also a constitutional lawyer. Everybody knows. He was Mr. M.K. Nambiyar's son, Mr. K.K. Venugopal, who is 89 years old. In a recent bed conference, this is what he has stated. The present Attorney General, an eminent jurist, and in a recent web conference has voiced his concern regarding judiciary. Judiciary is venturing into fields which are not allotted to them and encroaching upon and usurping the role of the legislature and the executive. Therefore, I would conclude by saying it is paradoxical to see that the Supreme Court, which evolved the theory of basic structure and said separation of powers is a part of the basic structure, don't append the basic structure of the Constitution, is the greatest. I mean, they are themselves now violating the law. I tell the Supreme Court awake to the real issue, and people, so that people could develop faith in the justice delivery system. Backlog of cases. So every year we get in a law day's report. The inflow of cases and outflow of cases are almost equal, meaning thereby the backlog of cases remains. If 10,000 cases are filed every year, only 10,000 cases or 9,000 cases are disposed of every year, meaning thereby the backlog of cases, which is more than 5 lakhs in High Court and about 78,000 in Supreme Court, it remains without being disposed. Therefore, let us all do the job that is assigned to us under the Constitution. And rule of law should prevail, and howsoever Supreme Court has said in another judgment, howsoever high you are, the law is above you. So it is for the legal fraternity like us to remind the Supreme Court, look here, howsoever high you are, the Constitution is above you. You are a creature of the Constitution. You don't turn yourself into Frankenstein's monster. Therefore, let us be very conscious about our role. I am not being upfront to the judiciary. I am only reminding the judiciary of the constitutional role that was given to them, which they seem to be forgetting in recent years. Thank you very much for this opportunity. This is my honest thought which I have shared in this legal conference. Thank you.